Good morning, everyone. Today's webinar is organized by the Commerce Department of Postgraduate Government College for Girls, Sector 42, Chandigarh. I, on behalf of Commerce Department, extend a very warm welcome to Professor Nisha Agarwal, Principal of the College, Dr. Aparna Singh, Faculty in Law, National Law University, Lucknow, UP, the resource person for today's webinar, Dr. Preeti Sharda, librarian of the college, my colleagues, and all the students on board. Today's webinar on consumer awareness will make you all rich in terms of consumer rights, duties, the redressal mechanism, and the scope of the Consumer Protection Act. The journey from Covet emptor, let the buyer be aware, to caveat vendita, let the seller be aware, was very revolutionary. Multiple judicial discourses led to the evolution of this new rule of caveat vendita, which imposes a greater responsibility on the sellers for goods and services they sell now. The onus now is on seller to make sure that the buyers make a reasonably informed choices and to compensate them for any defective goods and services. With this brief background, let us now begin the proceedings of the day. I request Professor Nisha Agarwal, Principal of the College, to formally welcome our resource person and let the webinar unveil. Madam Principal, please.
Thank you, Poonam. Good morning, everyone. On behalf of the students and faculty of commerce of PG GCG 42 Chandigarh, I extend a very warm welcome to our keynote speaker, Dr. Aparna Singh, faculty in law from Ram Manohar Lohia National Law University, Lucknow, to this webinar on consumer awareness. All human beings at all stages in life, right from the time they get up in the morning till late evening, consume a number of goods and services. And their decisions to buy a particular brand for these goods and services is influenced by quality, price, safety, after-sale service, aesthetics, etc. of the product. Therefore, in order to protect consumers against unfair trade practices, defects in goods, and deficiency in services, Consumer Protection Act was passed. The act significantly impacted how businesses approach consumer complaints and empowered consumers to a greater extent. It was regarded as the Magna Carta in the field of consumer protection. But as the trade and trade styles transformed with the change in technology, the ambit of Consumer Protection Act needed expansion, and the Act was therefore revised in 2019. Today's webinar will discuss the journey from 1986 to 2019 with real-life examples. I'm sure today's webinar will leave you all more informed, more aware, and better equipped to deal with your rights as consumers. So once again, I welcome Dr. Aparna Singh and dear student participants to this webinar.
Thank you, ma'am.
Thank you, Nisha. Thank you so much. Now I invite Gitanjali to formally introduce our resource person, Dr. Aparna Singh. Gitanjali, please.
Good morning, everyone. Little knowledge is a dangerous thing. A famous saying very aptly applies to the consumer of today. Even when he's making a single purchase, be it offline or online, knowingly, unknowingly, he is dealing with a number of agencies and thereby is expected to be vigilant, cautious, careful, and alert. Else he's prone to deception and fraud. Can't say about others, but we cannot expect commerce students to go through such harrowing experiences. And thus we have Dr. Aparna Singh with us, who is the key speaker of today and will enlighten you all on your duties and rights as a consumer. Dr. Aparna Singh, an assistant professor of law, has obtained the degree of BA, LLB, LLM from the University of Lucknow and has been awarded PhD in law from Baba Saheb Bhimrao. She has qualified UGC NET in December 2008 and June 2010 and has been a recipient of a gold medal for land laws, gold medal for civil procedure code, and gold medal for being the best student of labor laws for her LLB examinations. As a meritorious scholar, she bagged Pratibha Samman in the year 2001-2. She has 2 books to her credit, Right to Information and Right to Self-Incrimination and Narco-Analysis, and commendably contributed to encyclopedia and magazines. In addition to this, she has published different research papers in edited volumes and journals of repute and has participated and presented papers in several national and international seminars, conferences, and workshops. She has been trained in international humanitarian law by ICRC. She has delivered special lectures and training programs and workshops as resource person and has been counseling the students enrolled in different programs of IGNO from 2010. She is in the expert panel of Gyanvani FM channel 105.6 megahertz, All India Radio, Prasar Bharati for socio-legal discourses and human rights. Her areas of interest includes constitutional law, human rights, international humanitarian law, criminal law, banking and insurance law, and cultural studies. So now I pass on the platform to Dr. Aparna Singh to share her expertise and to enlighten you all on consumer awareness. Thank you. Yes, ma'am.
Thank you, Gitanjali ma'am. Very good morning to all of you, and a very good morning to Principal ma'am, Professor Nisha ma'am, Dr. Purnima ma'am, Preeti Shada ma'am, and Gurjinder sir. First of all, thank you very much for inviting on such an important topic, I think, for discussion today, because I think the most difficult task as we are going in the technological era. So I think consumerism has been expanded so much, as has already been reflected in the introductory note of Nisha ma'am as well as Purnima ma'am. So I think it's very well apt chosen topic for the student for a brief discussion on consumer today. And I think this is a girls' college, and girls are more prone towards the shopping. We as a women's are very much prone towards the shopping, online shopping. So how aware we are, how much rights we are knowing ourselves. That's all I think becomes very important today in this modern technological era. So thank you so much for inviting me for the lecture today. And since the topic has been a discussion on consumer awareness, the title as such being given for the webinar is consumer awareness. So if I say why we should need for a consumer awareness, now you see the market, if, as I said today, is flooded with very large number as well as variety of goods and services. The numbers of producers and final sellers of the commodities are increasing many folds day by day. So it is very difficult to know now who is a genuine producer or seller. Now, it is not possible, you see, practically for the consumers to personally come in contact with all the producers or sellers, especially when we do the online shopping. And since as I will just make a discussion, detailed discussion on Consumer Protection Act of 2019 and the big change that act has brought with the e-commerce, mainly due to which you see the act has been, you can say the 33-old Act of Consumer Protection Act 1986 has been replaced with Consumer Protection Act 2019. So I think because of the e-commerce, the main thing that has been added in the act. So I'll come to make a detailed discussion on how the information technological era has changed the consumer 33-year-old Consumer Protection Act of 1986. But as I said, that why we need to have the consumer awareness. So as I said, it is not practically, possible for the consumers to personally come in contact with the producers or sellers. Moreover, if you can say, in the era of advanced information technology, the physical distance between the consumer and the product sellers has also increased. Since consumer can get we can get the commodities at our doorsteps by booking the orders, or you can say over telephone or through internet. So similarly, you can say among large varieties of commodities, it has become very difficult to know as to who is a genuine producer, who is a genuine seller, and what are our rights towards this when we feel grievance after, you can say, making such kind of orders online. Especially, it's very easy when we make a physical contact with the producers and sellers, and we can easily settle our grievances with them. But when it comes to e-commerce, especially when it comes to in the digital age, the things have become a little bit complicated. And since from the last 1 year, we all are struggling with the pandemic, you see, kind of situation where everything is dependent on the digital things now. So I think I'm sure that each one of us must have shared one or the other thing related with the problem of consumerism now. So I think we have done a lot of shoppings in the last 1 year due to lockdown, and how our problems are solved, whether we were able to sort out our problems in case if the good found defective, or whether some kinds of problem has arisen with the products that we have purchased online. So that is somewhat I mean to say that it's become very tricky to know in this digital era that who is a genuine producer, who is genuine seller. And sometimes you see a lot of internet frauds takes place, because sometimes in the name of a franchisee, in the names of sponsored companies, there has been displaying of advertisement, and we are just stuck when our money go in waste by ordering those things, and we didn't get our products what we were expecting. So similarly, I mean to say that how the things could be resolved, but ultimately, because it is the awareness, because we are studying the law, we should know our law. So I think how much aware we are about our rights, that is important. How we can catch all these defaulters, how can we catch these people who are making fraud. So I think that has become very important. Now, people, you see, basically, if I say what you mean by consumer awareness, because the thing, under the consumer awareness, there are a lot of things to be understood. As the Act itself has detailed out everything, we will come for a detailed discussion on Consumer Protection Act of 2019. But you see, when it comes to consumer awareness, how do you understand what we should aware about it? Now, for example, especially the knowledge of the products which has been purchased by the consumers, in terms of its quality. For example, you can say the consumer should know whether the product is good for health or not, whether the product is free of creating any environmental hazards or not. So I think the one is very important thing that comes under the consumer awareness is about the knowledge of the product. And also the education, consumer awareness education about the various types of hazards and the problems, you can say, which are associated with the marketing of the products. For example, one way of marketing a product is advertisement, basically through newspapers or television. So you should understand that how much these advertisements, consumer should have the proper knowledge about or you can say the proper education about the effects of these advertisements. Sometimes merely by the lucrative offers through the advertisement, we consumers get attracted and we purchase the things. Ultimately, we face a lot of issues after that, and that issues, if not get resolved, we get frustrated, we get disappointed. So ultimately, I mean to say, the education about the kinds of hazards that a product may brings to you, that is also very important to understand. And very importantly, what are your rights, what are the consumers' rights, the knowledge about the consumer's right. This means that first, the consumer must know that he or she has the right to get the right kind of product. So this is her right, this is, you can say, consumer right. Secondly, if the product, you can say, is to be found faulty in any manner, the consumer should have knowledge of making the compensation, of making that person, you can say, punishable as per the law that we have under the law of the land. So I mean to say, consumers' right is very important to know. This comes under the consumer awareness. And also, what is the consumer's own responsibilities? This implies that the consumers themselves should not indulge in any you can say, unnecessary any kind of unnecessary consumption, or any wasteful or unnecessary consumptions. So when it comes to consumer awareness, you can say consumer awareness is a combination of number of things, but especially if I point out certain combinations of the points under the consumer awareness, as the title of the webinar says, you should understand that, since, as I said, that market is flooded today with number of buyers and sellers, so how we should get aware about our right. So consumer education, consumer rights, consumers' own responsibilities, and the knowledge of the products is very important to understand about the products, or you can say about the things that we are saying. Now, you see, if I say, as per, you see, if you go with the data, as per the Ministry of Communication, Government of India, if I say today, the number of internet users in India is expected to grow 730 million by year 2020. So I think we are in the year of 2021. So I think you can understand that to what extent there is an increasement of number of internet users, and accordingly, in the digital era, the same way the online shopping and the online things are getting, you can say, more advanced day by day. So due to, you can say, adoption of digital technology, especially on the one hand, especially e-commerce entity, where transactions occur, you can say, directly with the consumers and multiplied rapidly at the same time, internet using consumers have grown very fast in the last few years in India. And keeping in view, you can say, this new set of challenges, especially in the digital era by consumers in the digital age, Consumer Protection Act 2019 was passed by the Government of India, which came into effect on 20th July 2020. And consumer protection, and with the same we have got now the consumer protection e-commerce rules of 2020. So it's not only important, you see, to go by the Consumer Protection Act of 2019, but at the same time it is also important to go by the e-commerce rules of 2020. That equally becomes important for the students to go in detail when you go with the Act of 2019. So basically, you can say the new act has replaced the 3-year decade-old Consumer Protection Act of 1986. So you can understand that, of course, it's not easy to replace a 33-year-old act, and why it was needed. I think it's a dire need of the hour to in the digital age to come up with such a legislation. Now, under the Consumer Protection Act of 2019, the very important point that has come, you can say, as I said, to understand who are the consumers under the Consumer Protection Act of 2019. See, the act is quite a lengthy one. And I think if we just make a discussion on some of the key features of Consumer Protection Act 2019, I think that will enhance the knowledge with you, so that at least that portion you must know, which are of the practical use, which are the practical use in our day-to-day life. So I think if we are more concentrating especially on those provisions where we are really fighting for it, I think that actually becomes important. So I'll just discuss few key features of the Consumer Protection Act of 2019. And I think with this, I think it is you will be able to fetch out some of the important things that you may apply in your practical life with the consumer, with the things that you are you can say daily in daily life that you are doing. So especially if I make you understand how the consumer has been defined under the Consumer Protection Act of 2019. Now, basically, a consumer under the Consumer Protection Act of 2019 is one who buys any goods or hires any services by paying price to the seller by offline or online transaction through electronic means, or by teleshopping, or by direct selling, or multi-level marketing. So here, if you understand consumer under the Consumer Protection Act of 2019, a consumer is one who buys any goods or hires any services by paying price to the seller by offline or online. And this is one of the major change you can say under the 2019 act has come, where the online transactions were not incorporated under the Consumer Protection Act 1986, and similarly there was no, you can say, redressal mechanism for the same when it comes to making the online things were not so easy and not so clear under the Consumer Protection Act of 1986, which is expressly mandated under the Consumer Protection Act of 2019. So basically, under the Consumer Protection Act of 2019, you can say the offline and online transaction through the electronic means or by any teleshopping, multi-level marketing, or direct selling has been incorporated. So such goods and services, you can say it may be bought or it may be hired, should be for his own use or for earning the livelihood, and it should not be for commercial purpose. So this is one very important thing, that the consumer is one who has purchased that good, you can say who has bought that good or who has hires that good for his own use or for his own livelihood, but not for the commercial purpose. So this is very important to understand the meaning of consumer. Now, Consumer Protection Act 2019 is also becomes important that it applies to which goods and services. Now you see the acts basically applies to all goods and services, as I said, including bought or you can say sold over the digital or electronic networks including the digital products, including, so it automatically you can say all those goods and services that are there under the digital era, or you can say the digital products have also been incorporated under the Consumer Protection Act of 2019. Rendering of any services free of charge or under a contract of personal services by an employee is not a service under the, you can say, Consumer Protection Act of 2019. So any free of, like you see, we have number of hospitals and departments. Sometimes they are providing the free services. Free कभी-कभी services होती हैं. कभी-कभी eye testing free करा देते हैं, कैंप लगाते हैं. तो जब हम free services आपको कहीं से कोई भी institution आपको कह रहे हैं कि they especially hospitals you see. And sometimes we get affected by the kind of camps, they are making it, and sometimes it may bring some kind of health hazards to us. So the problem becomes that whether the services which has been provided free of charge or under any contract of personal services, when services you can say rendered by the employee to his employer, that is personal services. So whether that being covered under the service under the act, because you may have the law where you can get the compensation for the kind of deficiency in services, for the kind of defects in services. So whether if any personal, this उसमें generally कभी-कभी ऐसा होता है कि हाँ आप गए आई टेस्टिंग करा, उसी में आपको प्रॉब्लम हो गई, फ्री कैंप में आपने करा ली आई टेस्टिंग, अब उसमें आपको प्रॉब्लम आ गई, अब आप उस पे अब गए उस कैंप पे केस करने के लिए, तो उन पे आप केस नहीं कर सकते, बिकॉज एज आई सेड द डेफिनेशन सेज जनरली क्लिनिकल सर्विसेज में भी ये प्रॉब्लम आती है। कई बार ऐसे स्टाफ्स होते हैं जो आपको फ्री सर्विसेज देते हैं पर्सनल नेचर के, एज आई सेड एम्प्लॉयर्स एम्प्लॉय का रिलेशनशिप में कभी ऐसी सर्विसेज आप दे रहे हैं, उसमें कोई प्रॉब्लम आ गई तो आप उन पे केसेस नहीं कर सकते। ये एक थोड़ा ड्रॉबैक भी है, चैलेंजेस भी है एक्ट में कि क्या इसको इनकॉर्पोरेट करना चाहिए, क्योंकि जनरली बहुत से ऐसे फ्री कैंप्स लगते हैं, बहुत सी ऐसी फ्री ऑफ कॉस्ट सर्विसेज मिल जाती हैं कंज्यूमर्स को, और कंज्यूमर्स पागल हो जाते हैं उसको लेने के लिए कि फ्री है भाई दौड़ पड़ो चल चलो, लेकिन कितना हेल्थ हजार्ड्स उससे हो सकता है, कितना आप उससे अफेक्ट हो सकते हैं। आई थिंक दैट इज वेरी इंपॉर्टेंट टू अंडरस्टैंड, एज आई से दैट एजुकेशन consumer awareness comes with consumer knowledge about your health hazards. So sometime free services of charge under a contract of personal services, as I said, is not being covered under the service under the Consumer Protection Act of 2019. So accordingly, I think for that you must get it clear that in case if you avail services through that, you are not going to get any kind of benefit through the law by way of compensation or by making the products or the product producers or the sellers or the manufacturers guilty. Well, just 1 minute. Yes, so I was talking about So this also becomes important, to understand the consumer definition and services under the now, when it comes to, as I said, the main thing that has been there under the Consumer Protection Act 2019. Why the act, as I said, brought changes. We have the changes is a major, you can say, things that has been brought with the e-commerce. So basically, you can understand, as I said, e-commerce is one thing that has been a major change in the Consumer Protection Act of 2019. So what is actually an e-commerce? What is e-commerce entity under the Consumer Protection Act? And what are the consumer protection, you can say, e-commerce rules of 2020? Now, e-commerce is basically, you can say, is the business of buying or selling the goods or services, including the digital products, over the digital or electronic networks. So this is all about e-commerce. And e-commerce entity, you can say, means one who owns, one who operates or manages the digital or electronic facility or platform for electronic commerce, where you can say buying or selling of goods or services, including the digital products, takes place over the digital or electronic network. So you can say an e-commerce entity should be a company that is incorporated under the Companies Act of 2013. Basically, earlier it was 1956 Act, which was replaced with the Companies Act of 2013. A foreign company which has been covered under the Companies Act 2013, generally an office or the branch or an outside India, you can say, which is owned or controlled by a person which is resident of India, as provided in the Foreign Exchange Management Act of 1999. So it is very important to understand, because e-commerce entity has been brought under the Consumer Protection Act of 2019. So when it comes to, you should understand that first of all, what is the legality of that entity. So for legality of entity, the proper registration of that corporate entity must be required. So for that, I mean to say, it is also a kind of consumer awareness. First of all, you may challenge that entity itself when it has not been proper registered under the Companies Act of 2013, or under the, even suppose it is a kind of foreign company, so it must have its registered office in India, a registered office, or which has been controlled by a person resident in India, as provided in the Foreign Exchange Management Act, FEMA Act of 1999. So we have the proper registrations rule of these corpus entities. So I think when it comes to e-commerce entity, one also things have to be pondered upon it, that whether that entity has been proper being registered under the things or not. One who operates, you can say, or manages digital or electronic products or platforms over the electronic commerce, where buying or selling, you can say, is taking place through the digital or electronic network. So this is very important. Now, e-commerce entities, you can say, where Consumer Protection Act 2019 and Consumer Protection E-commerce Rule 2020 also applies. For example, it applies to marketplace e-commerce entity. A marketplace e-commerce entity, you can say, which provides an information technology platform, includes, you can say, any website or any mobile applications on a digital or electronic network to facilitate the transactions between the buyers and sellers. So in the electronic commerce rules, it has been provided. There has been inventory e-commerce entity also. So inventory e-commerce entity is one, you can say, who owns the inventory of goods or services and sells such goods or services directly to the consumers, and shall includes the single branch retailers and multi-channel single brand sellers. So this is inventory e-commerce entity which has been defined. There is also e-commerce retailers. E-commerce retailers is also multi-channel single brand retailers, and single brand retailers, you can say, in single or multiple formats. E-commerce entities, you can say, they may have the, you can say, they may establish outside India, but systematically they offers the goods or services to the consumers in India also. So I mean to say, when it comes to application of rules for e-commerce entity, there has been, you can say, these things have to be kept in mind, because e-commerce is one major change that has been incorporated under the Consumer Protection Act of 2019. Now, there is some important, you can say, things that, if I say do's and don'ts of the marketplace of e-commerce entity and inventory of the e-commerce entity. Now, there has been, things that is to ensure the details of the goods and services on the platform as regards to its appearances, nature, quality, purpose, or any other feature by obtaining an undertaking in this regard from the seller. As I think Madam Purnima has begun her lecture, has begun the introductory remark by saying that this is not the age of caveat emptor, which was considered at one point of time as the cardinal principle of commercial law, where the buyer has to be aware. और आप देखिए बहुत पुराना कैंपेन चला, जागो ग्राहक जागो, अब वो भी रिप्लेस हो गया, क्योंकि अब वी आर इन द एज ऑफ caveat vendita, where seller has to be aware. So similarly, you can say it is one of the responsibilities of the under the for the e-commerce entity or the inventory e-commerce entity to ensure that the details of the goods or services which they are providing on the electronic platform or on the digital platform must be accurate as regard to their appearance, as regard to their nature, as regard to their quality, purpose, or any other feature, by obtaining an undertaking in this regard from the seller. Also, they have to display the information clearly on its platform for its users, related to return, related to refund, related to exchange, related to warranty, guarantee, delivery, shipment, including the cost of return or shipping. तो कई बार आप देखिए ऐसी फेक वेबसाइट्स होती हैं जहां ये चीजें ही नहीं होती और हम इन पर ध्यान नहीं देते. कभी कभी these are very petty things. We just open the website and we do the shopping और पेमेंट कर देते हैं. उस पे क्या हम उनकी ये डिटेल्स इन्फो, because you know, as I said, the very important thing, what are the, if I say, राइट्स ऑफ कंज्यूमर्स. कंज्यूमर्स के राइट्स आपको पता होनी चाहिए. तो कंज्यूमर्स के राइट्स ही होते हैं कि उनको राइट टू बी इन्फॉर्म्ड. दे हैव टू बी इन्फॉर्म्ड, दे हैव टू बी एजुकेटेड इन दिस रेफरेंस. सो somewhere I mean to say that you have to take care of this thing, that whether there has been proper displaying of information related to the return things, related to the refund, related to the exchange, related to warranty, guarantee, delivery, shipment charges, including cost of return or shipping, mode of payment, and the grievance redressal mechanism to enable the consumers to make the informed decision about their purchase of goods and services. So this is one of the obligation, you can say, on the e-commerce entity or the inventory e-commerce entity to do the same under the Consumer Protection Act of 2019. अगर नहीं है तो ये खुद में एक defective websites होती हैं. So to display all the information, you can say, clearly related to seller, their business addresses, customers care number, ratings or feedback, etc., for enabling the consumers to make the informed decision for the purchase of goods and services. They must also display clearly the total price of any goods or services in the single finger, along with the, you can say, breakup showing all charges such as delivery charges, postage charges, handling charges, conveyance charges, and the applicable tax. All these things should be displayed clearly. There should not be any kind of hidden information. To provide also the numbers, ticket numbers for each complaint to the consumers for the purpose of tracking the complaint status by the consumer. This has been added under the e-commerce entity. ये सारी चीज कभी कभी हमें नहीं मालूम होती. एक आईडी आपको मिलती है ट्रैक करने के लिए. वो चीजें जब आप डिजिटल प्लेटफॉर्म पे शॉपिंग कर रहे हो तो इन पे थोड़ा आपको अवेयर होना चाहिए कि क्या ये चीजें इस वेबसाइट, तो वो एक ऑथेंटिक वेबसाइट आप मान सकते हैं शॉपिंग करने के लिए. अदरवाइज आपको, क्योंकि ई कॉमर्स एंटिटी रूल्स के हिसाब से 2020 के हिसाब से you have to understand this thing, that whether these kinds of things have been properly displayed or not. Now, to provide a ticket number for each complaint, as I said, to the consumer for the purpose of tracking complaint status by the consumers. Also to provide the, you can say, all informations, as I said, related to refund, related to refund, exchange, warranty, guarantee, delivery, shipping modes of payment, and grievance redressal mechanism to enable the consumers to make informed decision and to ensure that advertisement for making of goods or services are consistent with the actual goods or services. So this is some of the important, you can say, do's and don'ts of the marketplace, e-commerce entity, and inventory commerce place entity. Also under the COPRA Act of 2019, there is also to provide it has been mandated to provide the information, to provide the information on its platform on available payment methods, including, you can, the security and the charges of such payment method. So generally we used to see this, but sometimes we ignore, and we become, you can say, a victim of our own unaware things. So I think it's also important to know the information on its platform method by including the security charges of the payment mode, payment method, procedure for cancellation of such payment under those methods, chargeback options, if any, or you can say any contact details for the payment service providers. Also, you can say they must provide all informations to it by the sellers and disclose the relationship with the sellers in terms and conditions of the business. must you can say display all kinds of notices, must disclose all mandatory notices and contractual informations which are required by the applicable laws. That must also be displayed. They also, the you can say e-commerce entities are required to explain the parameters for determining the rankings of goods or sellers on its platform through publicly available descriptions drafted in the plain language, and to bear the liability in any action related to the authenticity of the goods or the services sold by them, where it guarantees that whether such goods and services are authentic. So some sort of, like, you can say, bearing the liability also comes under the things. Also, you can say do's and don'ts of markets of e-commerce entities and inventory e-commerce entity. You can say is not to represent itself falsely as a consumer and post reviews what goods and services misrepresents the quality or the features of any goods or services. Not to represent itself, you can say, falsely as a consumer and post review. This is also becomes important for the consumers also, because sometimes what happens that these e-com, we just read the reviews of the consumers, and on the basis of the review we do the ratings and we do the shopping. So you should be aware that whether those reviews are true, whether those reviews are not false. So you can say that sometimes it's also an obligation on the e-commerce, that once they are caught that they are themselves making the review of their product and placing it and displaying it on the internet, it's a kind of, you can say, a kind of don't it's the kinds of rules that has come for the e-commerce entity, that they should not represent itself falsely as a consumer and post reviews about the goods or the services, or misrepresent the quality of the features of the goods or the services. Not to represent itself falsely as a consumer and post reviews about the goods and services. Not to conspire or abet, or you can say aid, in the commission of any unlawful act using any third party information hosted by them, and also to remove or disable the access of the material in its computer resources used to commit any unlawful act at that resources without vitiating the evidence in any manner. So this is also a kind of obligation or duty on the e-commerce entity and the inventory e-commerce entity, not to refuse to take back goods. They are not see they cannot make such kind of provisions where they are making the refusal of their own products, or withdrawing or discontinued services, or refuse to refund the considerations if such good services are defective, deficient, spurious. I mean to say that if you are aware about this, then you can take the law in your own hand, and then you can make the person aware, even the sellers and the producers and the manufacturers, that how they should display the things on the digital platform as related with the e-commerce thing, because that is what being there under the main thing that they that has been added under the 2019, and that has actually made the replacement of, as I said, 33-year-old Consumer Protection Act of 1986. So if you are saying that sometime there has been refusal of the goods, they are not making such kind of any provision in their products, that there can be taking back of the goods, or withdrawing or discontinue services, or refuse to refund the considerations of such goods and services which are defective, which are deficient, which are spurious, or not as advertised or agreed to, and or it may be sometime delivery is late, then you may also pursue the case in the consumer's court. Sometimes there has been a month delay delivery and they are not responding to it, and customer become disappointed and frustrated. So that is, I think, is very important to know that how you can take the law and make punish for these e-commerce entity if they are defaulters. The very important thing, you see, for the e-commerce entity on a marketplace, you can say there has been a very certain important duties that has been imposed on the you can say on these e-commerce entities under the COPRA Act of Consumer Protection Act of 2019. Now, there has to be, there has been, you can say, a duties on the sellers to execute a prior written contract with the respective e-commerce entity for offering and selling the goods or services, to appoint a grievance officer who redresses the complaint within 1 month from the date of the receipt of the complaint. This is important to ensure that the goods or the services are consistent with the advertisement which are made in this regard. To provide to the respective e-commerce entity for displaying on the respective platform its legal name, address, name, and details of the websites, email addresses, customer care contact details, PAN details, all contractual information as per the law. So this is also important for e-commerce entity to provide, you can say, for displaying on all the respective platform the total price in the single figure of any goods or services, along with the breakup prices, you can say, showing all the compulsory and voluntary charges such as delivery charges, postage charges, handling charges. They should display it to provide, you can say, for displaying on the e-commerce platform all mandatory notices and information provided by the applicable laws and expiry dates of goods being offered for sale. So I think also there has been displaying on the digital platform all relevant details about the goods and services that are offered for sale by the seller, including the country of origin, the name, contact numbers, designations of the grievance officers, name and details of the importers, guarantee related to the authenticities and genuineness of the important products. So you can say this is also important for the e-commerce entity not to adopt in any unfair trade practices, not to falsely represent themselves itself as a consumer, as I said, and post reviews about the goods or services, not to refuse to take the defective, deficient, spurious goods or withdraw any discontinued services or refuse to refund payment. These are certain important duties, you can say, that has been laid down under the Consumer Protection Act of 2019. So if I say a very important thing that has brought changes under the Consumer Protection Act of 2019 is with e-commerce and e-inventory commerce entities, for which there has been certain obligations and things that has been made mandatory to them. And I think they are about to adhere to it. Otherwise, it is itself challenging, and as per the law, they can be held as defaulters and can be punished accordingly. Now, when it comes to another important feature, as I said, under the Consumer Protection Act of 2019, the very major change which was missing under the Consumer Protection Act of 1986, which was not there, and under the 2019 we have the Central Consumer Protection Authority. Central Consumer Protection Authority is under the Consumer Protection Act of 2019 has mandated a provision, you can say, to establish a Central Consumer Protection Authority to regulate the matters relating to the violation of the rights of consumers, unfair trade practices, of false or misleading advertisement, basically. And basically, if you see any kind of false and misleading advertisement in this regard, the complaint can be forwarded to Central Consumer Protection Authority, who shall have, you can say, they have an investigation wing, and after investigation wing, they can pass the directions for recalling of those goods or withdrawal of those services which are dangerous, which are hazardous, and which are unsafe. They can also pass, you can say, the Central Consumer Protection Authority can also pass the direction for reimbursement of the prices of the goods or services and discontinuations of the unfair practices. In case of misleading advertisement, the Central Consumer Protection Authority, you can say, may also issue the direction to the concerned manufacturer or endorser or advertiser or publisher, as the case may be, to discontinue their services or to modify such kind of advertisement, they have also the power, you can say, the Central Consumer Protection Authority have also the power to impose a penalty of rupees 10 lakh on the said endorser in the first instance, and rupees 50 lakh for every consequent contravention. So if they're repeating, it get double, it gets 50 lakh for subsequent contravention. So I think this is another important key feature under the Consumer Protection Act of 2019, where CCPA, you can say, has been established, and which have the ample power, you can say, to investigate, to inquire about these manufacturers if they are making the false and misleading kind of advertisements, or you can say they are making any kind of unfair trade practices. They may lay the heavy penalty of rupees 10 lakh, and subsequent contravention, as I said, 50 lakh. Now, there has been a provision for this is becomes important. There has been a provision for penalty and punishment for offences under the Consumer Protection Act of 2019, and for that also there has been the rules of Consumer Protection e-commerce rule of 2020. Now, for, you can say, as I said, the Central Consumer Protection Authority has also is always been there, which can inquire and investigate. So if there is non-compliance of these directions of Central Consumer Protection Authority by any person, it shall be imprisonment for a term, you can say, which may extend to 6 months, or fine, which may extend up to 20 lakh rupees, or both. So it is compoundable offense under the Act. So this is what I said, that if there is non-compliance, means once they have issued the directions to modify it, once they have issued the directions to cancel this kind of advertisement, or to replace the advertisement, or to modify the advertisement in any way, whatever the kind of, I mean to say, the direction has been passed by the Central Consumer Protection Authority, and if they have been if the commerce entities have making the non-compliance of it, they are not adhering to it, they have to go for the, you can say, imprisonment as well as the heavy fine up to rupees 20 lakh. Any manufacturer, you can say, or any service provider who causes the false or misleading advertisement. This is very, very important, because we come across a lot of false and misleading advertisement these days. We shall be punished, you can say, with an imprisonment for a term which may extend to 2 years, or with fine which may extend to 10 lakh. With 10 lakh rupees, and for every subsequent offences it may extend to 5 year, and fine which may extend to 50. So you can 50 lakh rupees. So it's a very heavy penalty, you can say. If again, if the manufacturer or the service provider who causes false or misleading advertisement. For any manufacturing products, you see, which are containing the adulterants, for the purpose of selling or storing or distributing or importing, depending on the magnitude of the injury or health hazard that has caused to the consumer, the Act has laid down the maximum punishment for such offences. For imprisonment, you can say, which may extend to life imprisonment, with fine which may not be less than 10 lakh rupees. So how gravely, you can say, the penalty has been put up in case if such kinds of, you can say, such kind of products which are containing the adulterants, and for selling, for storing and distributing, or to what extent the injury has been there to the consumer, or any kinds of health hazards to the consumer, there has been the life imprisonment as well under the Consumer Protection Act of 2019. For manufacturing, for sale, or for storing or selling, or distributing or importing spurious goods by any person, depending on the magnitude of the or injury of the causes to the consumer, the Act has laid down the maximum punishment for such offences also, for a term which may not be less than 7 years, which may extend also to life, imprisonment for life, and fine which may not be less than 10 lakh rupees. So if you go by the penalty and punishment under the Consumer Protection Act of 2019, as well as for contravention of the Consumer Protection e-commerce rules of 2020, there has been this kind of heavy penalty. So even if there is any manufacturer who is storing or selling or distributing or importing such kind of spurious goods by any person, it may also depends on the magnitude of injury. This is very important. Now, if I say another important thing, that how to make a complaint under the Consumer Protection Act of 2019. Now, it talks about under the Section 17 of the Act. Section 17 of the Consumer Protection Act 2019, it states that the complaint relating to the violation of consumer right or any unfair trade practices, any trade fair practices or false or misleading advertisements which are prejudicial to the interest of the consumers as a class, it may be forwarded either in writing or in electronic mode to any one of the authorities, namely you can say the district collector or the commissioner at the regional office, or the central authority. Under the section Central authority under the section 21 has been provided, you can say, with the powers to issue the directions and penalties against the false or misleading advertisement. So complaint can directly be made in writing mode or in online mode to the district collectors or the commissioners at the regional office. Now, the very importantly thing that has also brought the change under the Consumer Protection Act of 2019 is the redressal mechanism, or you can say the court system. With court system, like for example, what is the redressal mechanism? Earlier, you can say we have district forums, state commissions, and national commission. Now, this has been replaced with the District Consumer Dispute Redressal Commission. District Consumer, you can say District Commission earlier, which was District Forum under the Consumer Protection Act of 2019. It has come as a District Consumer Dispute Redressal Commission, which you can say consists of a president and not less than 2 and not more than such number of members as may be prescribed with the consultations of the central government. Now, the District Commission, which was earlier the District Forum, has now the jurisdiction to entertain the complaint, where you can say the value of the goods and services paid and consideration does not exceed to 1 crore rupees. 1 crore rupees. So this is very important. You can say the district forum, where you can say, which was under the 1986, it was only up to 20 lakh. So this has brought a major change. If you see under the Consumer Protection Act of 2019, the District Commission now has a jurisdiction to entertain the complaint, you can say, where the values of the goods and the services paid as a contribution does not exceed 1 crore rupees. So from 20 lakh to 1 crore, the jurisdiction has increased. It's a big change. Under the section 34, if you go of the Consumer Protection Act of 2019, section 34, clause 2, subclause D, it categorically states, you see, that the complaint can now be instituted as a district commission within the local limits of whose jurisdiction the complainant resides, or personally who is working for gain, apart from filing the jurisdiction where the other side actually or voluntarily resides or carries a business or as a branch office or personally works for gain. So this has also been a major change. Now, state commission, you can say that the jurisdiction of a state commission to entertain the complaint has also been changed, where you can say the consideration exceeds 1 crore rupees, but it does not exceed 10 crore rupees. So earlier, you can say it was to 1 crore, now it is to 10 crore. So 10 crore rupees, the jurisdiction has increased to 10 crore rupees, whereas earlier it was from 20 lakhs to 1 crore in the 1986 Act. Now, similarly, under the jurisdiction, if you see, look of the National Consumer Dispute Redressal Commission, which is previously known as National Commission. The National Commission now have the jurisdiction to entertain the complaint where the consideration paid exceeds 10 crore rupees. So exceeds 10 crore rupees, you can say it is above, earlier it was above 1 crore. So now in the 2019, it is above 10 crore. 10 crore rupees. The jurisdiction in which the complaint has to be filed is now, you can say, on the basis of the values and the goods and services, which was not in the case of 1986, where it was value of the goods and services and the compensation, if any, claim. So basically, you can say there has been a major change under the jurisdiction of these district commission, national commission, and state commission, which was earlier the district forum, state commission, and national commission. So I think the jurisdiction from which was earlier in district from 20 lakh, it has been gone under the 2019 Act to 1 crore. For the state, it was 20 lakh to 1 crore. In the new Act, it has come to 1 crore to 10 crore, and in the earlier in the 1986 for the National Commission, it was only till 1 crore. It has come under the 2019 from 1 crore to 10 crore. So beyond 10 crore rupees, exceeds 10 crore rupees. So I think it's a big jurisdiction now where where things have been clear. A very important change also under the 2019 Act has also a great emphasis, you can say, has been placed on the mediation. There has been an alternative dispute redressal mechanism through mediation. So you can say this is another important feature under the new Act. New Act has provided the provision for mediation as an alternative dispute redressal mechanism, and you can say making the dispute adjudication more simpler and quicker. So through mediation also the things could be resolved. You can say this alternative dispute redressal mechanism will obviously provide a speedier resolution of disputes and reduce, you can say, the pressures on the consumer courts, which has already, you can say, the numerous cases pending with them. So generally, if the matter has been resolved fully through the mediation, it's well and good. The parties can settle through mediation and accordingly can decide the compensations between them. But if partly the matter has been solved through mediation, then half of the matter will be resolved through the court system as per the decision of the parties. So I think this is also to be understood that if fully mediation has taken place or partly mediation has taken place, accordingly the things have to be looked into. Now, as I already referred, the offenses and penalties in the provision, this becomes important that under the section 21, if you see, of the clause 2 or section 89 of the 2019 Act, which provides for the central authority with the power to impose a penalty in respect of any false or misleading advertisement by a manufacturer or an endorser. It may by order impose or manufacture or endorser a penalty, you can say, which may extend to 10 lakh rupees. So this is very important. Apart from this, you can say under the Consumer Protection Act 2019, a separate chapter for offenses and penalties have been introduced under the Chapter 7 of the Consumer Protection Act of 2019. Where you can say detailed penalties and punishment have been mentioned in relance to non-compliance or manufacturing for sale or storing or selling or distributing or importing products that are adulterated or spurious. So I think if you look at some of the very important key features of Consumer Protection Act of 2019, we got the background of e-commerce entity, what are the duties and obligations of e-commerce entity. We coming to know a major thing that has come under the like of the Central Consumer Protection Authority. We have come with the jurisdiction part that is that has been brought a major change under the Consumer Protection Act of 2019. Then we also come across that alternative dispute redressal mechanism is another important thing that has been added under the Consumer Protection Act under the new Act of 2019. Now, offenses and penalties, another important thing that has been added. And I also request you that once you go with the e-commerce part as a duty, then you must also read fully the rules that has been mandated for them. Now, I think that's a major things that have been brought under the changes. I think I must take a few cases for you, and that is interesting to understand. understand. And also, as I said, in the new act, there is also the provision for e-filing of the complaint, because there may have been the questions, that online filings are the important hai. So even the new act has provide the flexibility to the consumers, to file the complaints with the jurisdictional consumer forum and located at the places of residences or works of the consumer. Now, this is unlike, you can say, the current practices of filing where at the place of purchase only, or where the seller has its registered address. The new act contained enabling the provision for consumers to file the complaints electronically and for hearing or examining the parties through video conferencing. So this also aims to provide the procedural ease, you can say, and reduce the inconveniences and harassment for the consumers. Now, if I take up the cases, as I said, that there has been, a number of things where, as an obligation, or things have been there as a duty that has been mandated for the e-commerce entity. I'll take up one case, very interesting case, as I said, that how the manufacturers or the producers or the sellers, they must not indulge themselves in the unfair trade practices. Now, this is a very good case of 2020, if I say, related with the Consumer Protection Act of 2. You have plethora of cases under the Consumer Protection Act of 1986. And moreover, they have at least provided the background of it, and at least those cases are still relevant if you come out with a deficiency of services when it comes under the COPRA Act of 2019 also. But unfair trade practices, you can say, should not be adopted by the e-commerce entity or the manufacturers or the sellers as an obligation and duty imposed on the 2019. Now, this is the case of Connaught Plaza Restaurant Limited, Kapil Mitra, in 2020. Now, I repeat the case, Connaught Plaza Restaurant Limited, Kapil Mitra case. Now, this is the case, you can say, where the complainant or the respondent has participated in the McDonald widely published scheme. The complainant, you can say, he has participated in McDonald widely published scheme. McDonald में खाओ हर बार प्राइज ले जाओ. मैकडोनाल्ड में खाओ हर बार प्राइज ले जाओ, ये उनकी एक प्रैक्टिस थी. बाय प्लेसिंग यू सेंड से 2 सेपरेट ऑर्डर वर्थ ₹80. हम सब मैकडोनाल्ड जाते हैं, खाते हैं, तो इसी पे एक केस मुझे इंटरेस्टिंग लगा, विच आई शुड शेयर विद यू. Now, you see, this has participated, where the complainant has participated in such a scheme, with the scheme says McDonald में खाओ हर बार प्राइज ले जाओ, by placing 2 separate order worth ₹81. Now, it was alleged by the complainant that the Connaught Plaza Restaurant Limited, a franchisee, it was a franchisee, the Connaught Plaza Restaurant Limited, it was a franchisee which was running the McDonald restaurant, has indulged in the unfair trade practices by not giving the assured prices as per the scheme. Rather, they have put the participants under the obligation to make further purchase of a minimum of ₹20 in order to avail free French fries. Also, you see, the complainant had to send 2 SMS giving the coupon numbers, for which ₹3 per SMS were charged. Moreover, the detail of the entire scheme with its terms and condition and the results of the winners were also concealed from the participating customers. Therefore, you see, the complainant in this case has filed a consumer complaint before the district forum, praying to declare the scheme as an unfair trade practices, and that Connaught Plaza Restaurant is directed to disclose the entire schemes and winners of the prizes. Now, the district forum, in this case, has allowed the complaint and awarded the compensation and compensation, and also the cost of the cost to the complainant, which has been there from ₹10,000 to ₹2,000. So I just gave an example that how this unfair trade practice was invited by the Connaught Plaza restaurant, and where this kind of they have invited the scheme, and the complainant was became a victim, and ultimately he filed a case for the district forum for the unfair trade practices because things were not clear, and accordingly he got a compensation of rupees 10,000 and 20. Now. Though the complainant has win the case in the district forum, but this Connaught Plaza restaurant, they have filed an appeal. You can file an appeal before the state commission, from district to state commission, state to national commission. So they have filed an appeal before the state commission, but state commission also, you see, in this case has modified the order of the district forum by enhancing the compensation. They have and awarding the damages, or you can say punitive damages, from rupees 2 lakh to 10 lakh. तो कहने का मतलब था वहां डिस्ट्रिक्ट फोरम में 10,000 ही उनको मिला, लेकिन 10,000 ही मिला, और उसको स्टेट कमीशन ने बढ़ा करके 20 लाख कर दिया, उसको सीधे डबल कर दिया, मतलब इतना ज्यादा अमाउंट कर दिया. तो इस पे जो है then again they have filed the before this Connaught Plaza have again gone for appeal under the National Commission. So National Commission also held that since there has been they have also, you can say, tried to in the National Commission the compensation amount was reduced to some extent for the Connaught Plaza restaurant, because as is it was said, the National Commission held that since there had been no proof which has been filed by the complainant that the Connaught Plaza had collected the SMS charges, or that it had an agreement with the telecom services provider on sharing the SMS charges, because the complainant was unable to prove this kind of proof, the order of the state commission, you can say, they could not be stayed on this ground. So on the other hand, it was also true to some extent that the scheme was unfair practice which was followed by the Connaught Plaza. So this was held by the National Commission also. So the fact having been established by the District and State Commission regarding the unfair trade practices has been, you can say, was found to be true. But later on, some amount of the compensation was modified by the National Commission on the ground of the SMS charges, for which the complainant was unable to provide the evidence. So partly, you can say, allowed the amount. The National Commission had reduced the amount from 70,000. They have reduced the amount. So this is what I think, this is a case I shared with you with respect to unfair trade practices, McDonald's case. So I think this is important, that if such kind of gaming activity they are launching for the customers and we are sometimes becomes unaware. So for this also the case has been gone in this case. Now, a very important case, you see, there has been the charging, the additional cost for carry bags when we were going under the pandemic, and lockdown when was there. I think everyone was doing online shopping though, but sometime before that also, when there was banning on plastic, there was the things that everyone has to carry their own bags. So many mall shops, you can say, shopkeepers were charging the carry bags at the payment counter. So charging, you can say, the additional cost for carry bags at payment without the prominent prior notice is also an unfair trade practices. It has also been held by the National Commission, National Redressal Commission, So ultimately, you can say the National Consumer, under the 20 Act and under the Consumer Protection Act of 2019, the National Consumer Dispute Redressal Commission has directed, you can say, the Big Bazaar to discontinue its unfair trade practices for arbitrarily imposing the additional cost of carry bags on the consumer at the time of making the payment. So this is very important. Then also, you see, we have the case of We have also the case, a very important case you see related with the medical services. That medical services also fall within the scope of, as I said, the Consumer Protection Act. We have a very landmark case of Indian Medical Association versus VP Shanta and others. Now, if I go with the factual background of this case, there was a case arises in a writ petition which was filed by the Indian Medical Education seeking the Supreme Court to declare the Consumer Protection Act doesn't apply for the medical professions. Now, the questions which were involved in the case that whether the medical practitioners can be regarded as rendering services under the Consumer Protection Act. Is medical services rendered is free or it will be covered under the Act? Now, which were the arguments that were provided by the Indian Medical Association was that reliance on the cases which states that such medical services by a government healthcare system is not a kind of services. The consumer protection mechanism provide that there must be an experts in the accountancy, the law, economics, industry, etc., but doesn't mention medical science. Therefore, the act intended to exclude the medical profession from its ambit. Now, reasoning of the verdict which was given by the Supreme Court that the medical practitioners and the patients carry within them a certain degree of mutual confidence and trust, and therefore the services rendered by the medical practitioners can be regarded as services of personal nature. But it is not a contract, and hence the exclusively word contract of personal services would not apply. Thus, the receiver of medical help is a consumer. So the court held that the district, the state, and the national forum can summon the experts in the field of the medicines. They can examine the evidences and generally act to protect the interest of the consumer. Thus, there is no legal bar or deficiency in examining the medical profession cases by the consumer court. So earlier, VP Shanta's case is landmark case because there is a lot of doubt, whether to what extent the medical, though, as I said, under the 2019 Act, if free of cost services being provided by the doctors or by clinical legal things, that being not covered under the 2019 Act. So doctors and hospitals, you can say, who renders without any charge whatsoever to every person availing the services would not fall within the ambit of services. That was there in the 86th Act also, and that has also been reiterated the same in the 2019 also. So in a government hospital where services are provided free of charge, the Consumer Protection Act will not apply. So if, however, they are paying customers as well as services, you can say being provided free, it will not be covered. So however, if the insurance policy company, you can say, pays for the treatment on behalf of the customer, and hence it will be covered under the Act. So you can say medical services should be rendered in accordance with the law. Now, there is also the case, you can say, the case of that no hair growth as promised in the advertisement. कई बार ऐसे advertisement आते हैं इसको इस तरह के cream से या medicine से false advertisements or misleading advertisement. So generally the consumer, in number of cases, if you see when it has been found making the false advertisement, whether like इससे hair growth हो जाएगी, इससे height बढ़ जाएगी, इससे आप मोटे हो जाओगे, तो कई तरह के इस तरह के कई बार misleading और false advertisements होके products सेलिंग होती है. तो इस पर कई आपको नंबर ऑफ केसेस मिल जाएंगे कंज्यूमर कोर्ट्स के, और बिकॉज कंज्यूमर कोर्ट्स इनफैक्ट आर पेनलाइजिंग द ब्रांड एम्बेसडर्स, for making this kind of false claim. Especially this is, you can say, the case of District Consumer Redressal Forum Thrissur, where the Consumer Court has ordered Dhantri hair cream, a film actor Anup Menon, the celebrity who endorsed the product in the advertisement, to pay the compensation, of rupees 10,000 each to the consumer for making the false promises. So it was the case of Kerala, you can say, Anup Menon, whereas a celebrity for making the false advertisement of Dhatri hair cream, where there has been a hair growth as promised, has also and he has endorsed the product, was allowed by the District Consumer Redressal Forum to pay the compensation of rupees 10,000. So we discussed, I think, the cases. There are also series of cases, but I think there is one more case where you can think like this is the case where you can say flat buyers entitled to just and reasonable compensation for gross delay by the buildings and handing the over possessions. So sometimes you see there is a number of time that we are booking our flats and the possessions have been delayed. So generally, if they flat buyers, they are entitled, you can say, to get the reasonable compensation for the gross delay, by the builders in handling over the possessions. Number of time, and this is, you can say, the case. This is also you can say one case where the Supreme Court has come up with the guideline after the cases have been filed in appeal through the Consumers Court. Then there is also one very important case of, you can say, under the medical profession, you can say, where the case of Arvind Shah versus Kamla Bain Kushwaha. Arvind Shah versus Kamla Bain Kushwaha. This is a factual background. If I say this is a case which arises as a result of the complaint, where Kamla Bain Kushwaha's a 20-year-old sons due to the medical negligency by a petitioner doctor. The mother alleged that the medicines prescribed had no relations to the ailment, whereas actual cause of death was said to be pulmonary edema. So the 20-year-old son died due to the negligencies of the doctor. So basically, the basic question, you can say, that came up before the National Commission was to answer that in what circumstances can a doctor be held guilty for medical negligency. There is an appropriate compensation for the case of medical negligency. So the reasoning and the decisions of the National Commission, you can say, is that if failure to write a proper prescription give rise to a guilt under the medical negligency. So the National Commission, you can say, in the Arvind Shah's case also held that while the doctor is indisputably held guilty of medical negligency by not issuing a proper medical prescription, there is no material available on record to conclusively establish the negligency of the doctor with the cause of death. The medicines prescribed were not related to established cause of death. As a result, the amount of damages ordered by the State Commission were reduced by the National Commission to rupees 2.5 lakh. I mean to say that when it comes to negligency, medical negligency, we often face, because this is an era where health hazards are often taking place, and number of diseases are taking place, due to which many times we get admitted in the hospitals, and due to negligency there may be some kind of health hazards comes to our life. So to what extent you can hold those persons guilty? So generally you have to preserve your medical prescriptions, because that is a kind of conclusive proof for the negligency of the doctors, which was held in the case of Arvind Shah versus Kushwaha. So I think accordingly you must keep the records as an evidentiary proof to take up your case before the Consumers Court. So I think there are a number of series of cases also, which I think we can share. I share with you on. I'll forward my PPT to the Gurjinder sir, and I think accordingly he will enhance more cases on the education. Also, there are cases. We have some live practical experiences also, which are not as cited in the case law, which has not been jotted on, but I'll just mail to the Gurjinder sir in the form of my PPT, which will be shared with the students. So I think it's already late, I think 1.5 hours, and I think that's the question answers round. So I must pick up the questions now.
Thank you, ma'am, for enlightening us regarding Consumer Awareness and Consumer Protection Act 2019. Now I'll take a few questions asked by the students. The
Yes,
first
sir.
question asked by Aarti and Myra from BCom first year. The question is, Ma'am, what are the different initiatives taken by the government for consumer awareness? The first question is that, ma'am.
Okay. Okay. Thank you, sir, for this question. I think this is very important question and very practical question. See, there are a number of government initiatives that has been taking place these days. First of all, you should understand that there is the consumer can register their grievances through the NSH app. There is an app called NSH. So if you download this app and register, you can just put up your register your grievances through this app. There is also an app called Umang app, which is there, which you can download easily and you can register. These are all the government initiatives. We have also, you can say, the National Consumers Helpline. So National Consumers Helpline are already there, NSH helplines where you can register your complaint. The Government of India, NSH, you can say Consumer Helpline is the Department of Government of India, Department of Consumers Affairs, Ministry of Consumer Affairs, Food and Public Distribution has prescribed this online complaint where you can register it. There is also, you see, a number of mail IDs being provided. Once you can. So I think when it comes to government initiative, basically these are the government's app which we can download and we can register your problems.
Thank you, ma'am. One more question from Myra student. That is, can consumer file online complaint where he or she have to file means sight and hearing is possible online through Consumer Protection Act 2019?
Yes, of course. As I said, that under the 2019 Act, there is the filing of online complaint, and online complaint, you can say you can also file directly your suit in the district consumer forum against it, but online filing is available on the website also. I think there is one website which I can name it where you can easily 1 minute. I have noted down actually the proper mail ID, sir, because I was expecting this question from the student.
Okay.
This question was expecting, so I have properly noted down that online forum where you can properly. I'll just mail you that proper
Okay,
online.
ma'am. Thank you, ma'am. Thank you. Now I would like to invite Dr. Poonam Agarwal for the remarks of the webinar.
Thank you, Madam Aparna. That was indeed an exhaustive presentation on consumer awareness. Madam,
Thank you.
I enjoyed the way you supplemented various provisions of the Act with real time so much. Reminds me of a case of Fair and Handsome Cream by Imami. The case dates back to 2015, and the District Forum in Delhi held that the Fair and Handsome ad by Imami was misleading. It directed Imami to pay 15 lakh damages to the complainant, 10,000 as the cost, also directed the company to withdraw the advertisement, representing that the use of the product will change the complexion from dark to wheatish and wheatish to fair. So we all as consumers should use our power to stop these unscrupulous sellers impose their products on us through misleading, deceptive, and false advertisements. Let us all be aware consumers. Thank you, ma'am. Thank you very much. Now I call upon Mr. Gurjinder Singh, co-coordinator of this webinar, to formally propose a vote of thanks. Mr. Gurjinder, please.
Thank you, Poonam Agarwal, ma'am. First of all, good afternoon to everyone. It's my great privilege to deliver a vote of thanks for today's webinar to all the dignitaries present online. First of all, I would like to thank our honorable guest speaker, Dr. Aparna Singh, for enlightening us with deep knowledge regarding consumer awareness, Consumer Protection Act 2019, rights and duties and redressal set up for the consumers. It gave deep insights into the topic, ma'am, and also revealed some interesting facts. The point where ma'am discussed relevant cases of consumer exploitation during the COVID time were very informative. I am pretty sure the precious knowledge that Dr. Aparna gave us will definitely help the students and all the faculty members in future. I would also like to thank our respected principal, Madam Professor Nisha Agarwal, and Dean Ma'am, also the head of the Department of Commerce, Professor Poonam Agarwal, for motivating us to organize this webinar. I'm also thankful to Dr. Preeti Sharda Ma'am, librarian Madam of the college, for her constant technical support and efforts so that event can be a great success. I'm also thankful to all the faculty members of the Department of Commerce and college for kind cooperation. Last but not the least, my thanks to all the dear students and listeners for their patience. I hope you all enjoyed every second of the webinar. And at last, there is a one important request to all the participants. Feedback form has been shared in the chat box. Please fill the correct details in the form so that we can send you e-certificates instantly. Thanks you once again. Thank you, ma'am. Thank you, ma'am.
Thank you, Gurjinder sir. I'll just respond the queries through mail to you. I think a proper online platform where they can register their complaint. It needs a proper website. So I think that I will properly mail to you so that you may provide the student. Thank you so much. It's my pleasure indeed.
Thank you, ma'am.
Thank you very much. And thank you so much, ma'am. We are signing off now.
Thank you, Preeti ma'am. It was indeed my pleasure. Thank you so much. Thank you, ma'am.
Bye-bye.